For Creamer Media's Polity, I'm Chanel Bruyn. Umunyana Rugege, an attorney with Public Interest Law Centre, Section 27, joins me in studio to discuss its submission on the National Health Amendment Bill. Welcome.
Thanks.
Why was it important for Section 27 to submit comments on the National Health Amendment Bill?
The National Health Amendment Bill is a very important piece of legislation in relation to the public and private health system in South Africa. Section 27 is a public interest law centre that uses and develops law to advance human rights. And we're actually named after the right in the Constitution that relates to access to healthcare services. So healthcare is one of our major interests, and that's why we thought it very important to participate in the public participation process.
And what are Section 27's main concerns with specific aspects of the bill?
And we overall looked at issues of independence of the Office of Health Standards Compliance and the areas of accountability and independence. So essentially we focused our submission on that broad area, and we looked specifically at the role of the Chief Executive Officer of the Office of Health Standards Compliance, who is the administrative head of the organization or the office. And we were quite concerned about the grounds for removal of the CEO of the office. The language in the bill refers to the ground of ill health, and this is quite a vague concept. And we made recommendations about tightening that language to ensure that the CEO can only be removed in very specific circumstances in which he or she is incapacitated and is unable to fulfill the functions of the office. Another issue we looked at is around the relationship between the CEO and the Office of the Ombud. The Ombud is located within the Office of Health Standards Compliance, and we were concerned about the lack of clarity regarding the relationship between the Ombud and what functions the Ombud carries out and the CEO. For example, it's not very clear from the language of the legislation what status the recommendations of the Ombud has. So for example, we raised some questions like, what is the status of the recommendations? Is the CEO obliged to carry out those recommendations? For example, if it's a recommendation for an investigation into a particular facility, is the CEO then required to go ahead and carry out an investigation? We asked the portfolio committee to seek clarity on this issue, because it's quite important that the ombuds functions are carried out independently, and that recommendations don't just sit on the shelf, because this is what the ombud is the office that the part of the office that the public will interact with. So it's very important for public perceptions of independence and transparency, and essentially just responsiveness to the public, that any recommendations that come out are taken seriously and are carried forward. We were also concerned about the appeal process. This is an area that requires a bit of clarity in our view. For example, just in terms of an appeal of a decision of either the office itself or of the ombud in particular, what recourse does a person have following from a decision or a ruling? And the wording of the bill suggests that the minister is required to appoint an ad hoc independent tribunal in order to adjudicate these appeals. However, our concern is that this can be read to say that the minister has to, in each case or in each appeal, appoint an ad hoc tribunal. This is problematic because it would require the minister to handpick a tribunal in each case, whereas in order to safeguard the independence of the tribunal, it's very important that it be a completely independent body that adjudicates a range of appeals, so that there's no perception that a particular set of people were instructed in a particular appeal. So we would like to see that language changed, and we've made recommendations in our submission to the portfolio committee to ensure that the appeal tribunal is as independent as possible.
Will the National Health Amendment Bill have any effect at all on government's plans to introduce a national health insurance?
The Office of Health Standards Compliance is a body that will ensure the quality and compliance with norms and standards in all facilities in South Africa. And this is essentially a very important building block towards NHI. NHI presupposes a functioning health system in which users are able to access quality healthcare services. And because this bill refers both to public and private health facilities, it's important for all of those health facilities to have the same standard of healthcare. So when a user approaches a healthcare facility, it shouldn't matter whether it's a public facility or a private facility where you would get less or more of a quality service in one or the other. So this is a really important building block towards NHI to ensure that all South Africans and residents of South Africa have access to quality healthcare services.
Thank you very much.